I can do what I want when I want to do it. I can do what I need when I need to get through it. When I need someone else, can't be too proud for help, but gotta look after myself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded, like how the clouds keep changing. I'm always steady rearranging, going back to the basics of what a good day is. What a good day is. And that's exactly what the day is. But it's exactly what you make it. So please don't go wasting. And I'll do the same, even if it's raining. How could I complain? And my feels got me feeling some type of way. You always free to take a break. Hope you feel what I felt. You gotta look after yourself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded, like how the clouds keep changing. I'm always steady rearranging, going back to the basics of what a good day is. 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 And that's exactly what the day is.
All right, y'all, it is that time. We are back in the building. Y'all know what to do. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. Let's go ahead and get into it. Shout out to everybody who's in here. We should be good. Ooh, there we go. Looking all crispy and clean on the screen. Let me make sure we're good. Oh yeah, we're good. I see the ones in there. Good morning, y'all. Welcome back to another YouTube live stream and another episode of the morning show. I'm your host, Classy Beats of ClassyBeats.com, patreon.com/ClassyBeats. By the way, y'all go check out the Patreon, and we are up in here. We got a great show for you. We're going to get back into the Jason Levesque, aka the Snowplow shooting trial. We've got some interesting court proceedings today. I did not know this was going to happen. Just found out earlier, and we're going to see some of the interesting things that are happening in court today. We got a support animal on the stand today. Yeah. We're also going to talk about the recent happenings between Drake and UMG. We've got some updates on Tony Buzbee, of course, as well. So we're going to go ahead and get into it here in a second. Before we do, I got to say what's up to the people, man. Shout out to everybody who's in the building. Of course, my awesome, amazing Amy is in here. Shout out to Amy. She just had a birthday yesterday. So in case y'all missed it, make sure you say happy birthday, happy belated birthday to Amy on her after birthday. Shout out to Amy. Thank you for everything that you do. We got A-Fits up in here. Valencia. Trisha's in the building. My dog Rice Street up in here. Taco Tuesday is in the building. Les Cleaver. Serotonin. I love that name. It's so dope. Serotonin's in here. Jay Buckmaster's in the building. Good to see you, Tanya. Good morning. And I think, oh man, I probably missed a couple of y'all. I apologize. But we're going to go ahead and get into it, because we've got a lot to cover today. So if y'all could, before we get started, please make sure that you like the video on your way in. Not only is it free, not only does it take 2 seconds, but it does let the algorithm know that you guys are enjoying the show, you're having a good time, you're learning a lot, and it shares the video and the channel out with more people. So if y'all could take a second and like the video on your way in, I would greatly appreciate it. Also, last night we had an amazing award show. Shout out to everybody who showed up to the show last night. We had a great celebration, not only of the many artists that make this community and this channel what it is today, but we also unboxed our 100K YouTube plaque, and I've actually got it here sitting over on my desk. We got this from YouTube. The plaque finally came in, y'all. We hit 100K. Let me see if I can, let me see if y'all can see it if I focus it that way. You can see my camera too. But yep, you can see it says right there, we've got 100K on the Classy Beach YouTube channel. Shout out to the gang. I'm going to put this, I don't know where I'm going to put it. I'm going to put it back here. I'll maybe hang it up over here or something so y'all can see. I don't know. Either way, I could probably set it here for now, just so y'all could peep it a little bit. Hopefully it doesn't fall. Either way, thank y'all again for 100K. I still cannot believe that that we hit 100K. I know Henry Resilient, my guy, he was one of the people that said it was gonna happen when it happened. Now I was just like, man, yeah, I don't know, whatever. It'll happen eventually. And sure enough, Henry Resilient was right. So thank y'all again for supporting the channel. Thank you for supporting the community and everything that we're doing here. We're going to keep continuing to grow. And who knows? I mean, we're going to hit 200K at some point. I told myself once I hit 100K, I was going to stop looking at it. So I'm not worried about the subscribers, but make sure y'all do subscribe and hit the notification bell so you don't miss any time that we go live or drop a new video. All right. With that being said, that's all the announcements I have. Let's go ahead and get into the show. So, first up, we've got some news on our guy, Tony Buzbee. If you're not familiar with the Tony Buzbee situation, this has been an absolute mess for Tony Buzbee. So, we saw some recent updated filings from Jay-Z, most specifically his lawyer, Alex Spiro. He came out and said, hey, this is what happened once Tony Buzbee decided to take a step back from participating in every piece of the legal aspects of this dismissal of Jane Doe's lawsuit. So Alex Spiro gave some insight into what was going on behind the scenes, the conversations that Alex Spiro was having with, we're going to call him Mr. K, now Tony Buzbee's attorney and the person who was representing him on these lawsuits. So Alex Spiro and Mr. K went back and forth, and Mr. K allegedly said to Alex Spiro, listen, if y'all don't do what we're asking, we're going to drop some more stuff on you. And I'm going to tell Jane Doe that you're threatening her, which was wild. Then we had the updates and we read the transcript from the private investigators that met with Jane Doe, where it was revealed that Jane Doe let the private investigators know that one of the lawyers, she said it was Tony Buzbee, we don't know who it is, but one of the lawyers she spoke with told her that Jay-Z was threatening her life. So all this goes back and forth. In the meantime, Tony Buzbee is facing a lot of legal battles, not only with Judge Torres, who he was supposed to have some information to by today, but also the Southern District of New York. So now we have an update from Tony Buzbee, and here's what's going to happen moving forward. Shout out to Megan Kuniff again, doing some amazing investigative work on this. And she posted this over on X last night. She said, Tony Buzbee has withdrawn as an attorney in the lawsuit against Sean Diddy Combs. Wow. Took you long enough. Shame on this man. After the judge ordered him to explain why he didn't disclose, he's not admitted to practice in the Southern District of New York Federal Court. Notice it was filed last night just before the deadline. What does this say? We've got John Doe, who Tony Buzbee was representing, versus Diddy and other people mentioned there. We have a notice of motion to withdraw appearance. Please take note that the pursuant to local civil rule 1.4b, Anthony Buzbee, an attorney for the plaintiff in the above captioned action, hereby moves to withdraw his appearance as an attorney of record until such time he is admitted to practice in this honorable district. Well, thanks for doing the right thing, Tony. Why did it take this long? I don't understand how this whole process goes, but if you're not admitted, he should have done this a long time ago. And then, of course, he says the plaintiff will continue to be represented by the remaining counsel of record for Cruis Law. Hopefully I said that right. And then, of course, forcefully submitted, I might add, Anthony G. Buzbee. And this is to, of course, the judge in this case, as we saw. Now, there is something else that came out about Tony Buzbee that we talked about, but I want to revisit here as well. Megan Kuniff also says they have an order from the U.S. District Judge Ronnie Abrams, which we talked about. The lawsuit against Diddy remains active, and Buzbee says his New York-based counsel will stay on the case, obviously. And they say to Judge Ronnie Abrams says it has come to the court's attention that Anthony Buzbee, who signed the complaint and several other filings on behalf of the plaintiff, has not been admitted to practice in the Southern District of New York. This was the whole issue and the whole reason there was the back and forth. And Alex Spiro brought it to the judge's attention, Judge Annalisa Torres's attention. And she said, hey, Tony, if this is an issue, we need to have this settled by the 18th. Here we are at the 18th. And now Tony Buzbee says, I got to go because the Southern District of New York saw the play. They knew what I was trying to do. As we mentioned, someone mentioned in the chat as well, I think it might have been Melody yesterday, that it's interesting that Tony Buzbee was doing this because he may have been signing all these claims and pushing everything through because he thought he could get some cash and that maybe someone would write a check. I'm noticing a theme when we see even the transcript from the private investigators that Celebrity B's name has been left out of pretty much everything. So it makes me wonder if Celebrity B has already written Tony Buzbee a check. He already had a win there. And whoever she is said, hey, just keep my name out of it. I don't want any trouble. Here's what I've got. And maybe one of the reasons why Jane Doe dropped this lawsuit in the first place, because it was going to be more of a fight than she wanted. And Tony Buzbee messed up. And there's so many other things on top of this. Either way, he wasn't admitted into the Southern District of New York. Moreover, although Buzbee was warned several weeks ago in a parallel case that this conduct violated Local Civil Rule 1.3 and 1.4, he failed to bring the issue to the court's attention. No later than March 18th, which is today, Mr. Buzbee shall file a letter explaining why he failed to notify the court about this issue earlier and proposing next steps to rectify it. So now we have Tony Buzbee saying, all right, guys, you win. I'm out of this. So the question is, what is going to happen with this moving forward? We reviewed the actual lawsuit of this John Doe and what he has going on in a separate video. I'll leave that in the description below. But what's going to happen to Tony Buzbee here? Because we've seen from him misstep after misstep when it comes to him lying about his client, when it comes to him setting up this wild NBC interview that made his client, notably one of his more notable clients in this Diddy lawsuit situation, just look foolish. Now they're having conversations. Tony Buzbee, I said leaks. Tony Buzbee gave a recording of a phone call he had with his client to ABC, and they showed that on Good Morning America. This is just a whole mess. So y'all will have to let me know what you think in the comments in the chat. What is going to happen to Tony Buzbee next? I have a feeling that this isn't the end either. Also, shout out to the gang in the building. There's Melody. She said, yes, it was me. I thought so. I got a little bit of a memory, not much. Melody says, yes, it was me. I think he never expected it to go this far, assuming everyone would settle out before it got public. I want to ask y'all in the chat too. Do you think Celebrity B already settled? Why haven't we heard from Celebrity B? Why hasn't Celebrity B been brought up? Is Celebrity B? Who is Celebrity B? I want to know. This is killing me. I personally think it's J-Lo. But also, yeah, y'all are saying because she paid out. It's just a weird situation, because if you look at the facts surrounding this claim, it couldn't have happened. So why would Celebrity B settle if this didn't happen? Y'all are saying it's J-Lo. The reason I would pay if I were Celebrity B is because I don't want my name to be brought up in any of this. I don't care if I was there or not. Just make it go away. I don't have time to deal with this. I've got other issues. If y'all are saying J-Lo, that's why Ben left her. Dang. I got other stuff I have to deal with. I don't have time to be fighting these crazy lawsuits. I'll write you a check and then be done with it. So there's that. But if it didn't happen, I mean, I don't know. To me, this looks better for Jay-Z that he fought it and the case got dismissed, not only for his business relationships, but it looks better for his reputation. People just say, hey, Jay-Z stood 10 toes down. He said he didn't do this. They dismissed the claim and they dropped it because he didn't do it. On the flip side of that, it's frustrating though, and I could see why Celebrity B might write a check, because Jay-Z, according to him, lost a multi-million dollar deal. That's a lot of money to lose for anybody, even Jay-Z especially. Some said maybe Mary J. Blige. I don't think so, but it's possible. But honestly, I don't think there was anyone, because I don't think it ever happened. But J-Lo was going through a horrible PR crisis at the time, so she might just not wanted to deal with it exactly. I don't think it ever happened to her. I don't think so either. There's no facts saying that it did, for sure. We've got over 400 of y'all in the building, by the way. Thank y'all for being here. Shout out to the gang. If you could, please make sure you like the video. I'm going to be begging for likes until y'all consistently show up and get those likes to 100%. Likes are free, y'all, and it really does help out the channel. Now, I know a lot of you are going to have a lot to say about this next topic. For those of you who are Kendrick Lamar lovers out there, y'all try not to take this personally, okay? And try and look at it from an objective perspective. I know it's tough, and I know you out there still chanting, they not like us. But we got to talk about Drake versus UMG. So let me find my picture of Drake and we'll get this up here. And I've got one more comment I want to read. Amy's talking about Tony Buzbee, or Tony Bugs Me. Yeah, shout out to Tony Bugs Me. Assaulters don't say file criminal charges ever. That's a fact. And that was when it solidified it for me. I don't know if y'all remember the live stream, we talked about it. When Jay-Z came out and he said, hey, if y'all want to file criminal charges, please go ahead. I was like, oh, dang. He didn't do this. He didn't do this. And those of y'all who are on the he did something train, if he did something, it wasn't this, because Jay-Z was standing 10 toes down. And then we did our own research. We had my guy, Dennis Byron, up here. Dennis Byron said, I was at the parties that night of the VMAs. We shut it down. Jay-Z, J-Lo, and Diddy were there until 3 o'clock, such and such in the morning. It is impossible that this could have happened. Then we saw the facts and evidence come out about the permit from the Jumbotron. Didn't happen. There's no way Jane Doe could have gotten to the limousines. Her own father said that she lied. I mean, yeah. It was pretty straightforward. What you about to say about my play cousin Kendrick? Oh, Lord. Now, we're not talking about Kendrick, but UMG is. And oh my goodness, this is interesting. Let me go ahead and make sure we're good to go here, and we're going to get into it. So, as you guys can see by the title, it looks like UMG is clapping back at Drake, and they're not having any of this. It's clear they don't want to get into the discovery phase of this lawsuit Drake has against UMG, obviously because of the things that might reveal. So they're trying to end this now. So Drake recently filed a lawsuit against UMG saying that they used some questionable and possibly illegal tactics to promote Not Like Us. Again, this isn't about Kendrick Lamar. This isn't about the beef. Y'all want to make it about the beef? That's fine. Drake made it very clear in his filings that this is not against Kendrick Lamar. This is against UMG using certain tactics and using their power and their influence with iHeartMedia, with Spotify, to not only push Kendrick to defeat Drake, but to diminish Drake's brand and his value so they can get a discount deal on Drake's re-signing that is coming up here very soon. Now, Drake came out, he filed a lawsuit, said, UMG, you can't do this. It's not fair. You need to pay me what I'm worth. At the end of the day, I think Drake was lame for filing this lawsuit. The reason being, he has benefited from this process his entire career. What measure he benefited from, I'll let y'all have that discussion. But I think if you're going to play the game, you got to play the game, Drake. You can't go out here and get mad at UMG for using the system that you benefited from against you. So with that being said, I also, on the other hand, think Drake has a great case here because the tactics that are used by UMG, we know historically, I know historically from being in the music industry, they're illegal and they're unethical. All right, let's just be real. UMG has a huge investment in Spotify, the world's biggest music streaming platform. They have huge influence there. They make certain deals with Spotify to push certain artists to do certain things. You can get into the botting conversation if you want to. Same thing with iHeartMedia. Same thing with a lot of these other platforms. So when it comes to the legal aspect of things, yes, I think Drake has a case here. And that's how we're going to look at it moving forward. So now recently Drake came out and he gave some more information and background and said, hey, UMG, y'all are wrong for this. I don't like this. This isn't fair. And I want to move forward. Not only do I want to move forward, but I want to get pretrial discovery. I want to make sure that I have everything that I need to prove my case. And UMG said, no, we don't want to do that. Because we don't want you talking to Spotify. Spotify's like, hey, UMG, sorry, I'm out of this. They call Drake up. Spotify says, Drake, what do we need to do to get out of this? Drake says XYZ. Spotify says, all right, we're gone. They're gone. iHeartMedia, same thing. They say, hey, Drake, we're not doing this. We're not trying to do what UMG's doing. Your fight's with them. Drake says, all right, cool. They call him up. They come up with the deal. X, Y, and Z. iHeartMedia is out of there. So now it is officially Drake versus UMG. And UMG is getting sick of it. They're moving to dismiss this claim entirely. And they don't even want to get to the discovery part of this. So what do they say? Shout out to Document Ting, says UMG's attorney filed a motion to dispute Drake's lawsuit. Drake's claims were called meritless and how public embarrassment from his beef with Kendrick Lamar is the real reason he chose to sue. Oh my gosh. That's not the case. That's not the case. And we're going to get into it here. Shout out to Document Tings for this. We're going to get into the full memorandum here. We're going to read the first few pages of this, but I want to first get into this motion from UMG. What do they say? They just filed this yesterday, and this is a notice of motion and motion to dismiss. Oral arguments requested. UMG, what do they say? Please take note that pursuant to Federal Rule of Civil Procedure 12B6, and upon the accompanying memorandum of law, request for justice notice and declaration of rolling a ransom, defendant UMG Recordings Incorporated respectfully moves that this court before the Honorable Jeanette A. Vargas at the United States Courthouse of the Southern District of New York, located at 500 Pearl Street, New York, New York, for an order dismissing the complaint for failure to state the claim. They're basically saying this thing is BS. Come on, Judge, get this out of here. So now we're going to hear more information from UMG on why they think the judge should go down this route and dismiss this claim entirely. Let's go ahead and get into it and see what they say. UMG Recording Incorporated memorandum of law in support of its motion to dismiss. So we're going to go all the way down here to the introduction, and it gets spicy right at the beginning. What do they say? Yeah, I want it all. That's why I strive for it. Diss me, you'll never hear a reply for it. Drake on Successful. Oh, man. We're getting into it already. The plaintiff, one of the most successful recording artists of all time, lost a rap battle that he provoked and in which he willingly participated. Instead of accepting the loss like an unbarred rap artist he often claims to be, he has sued his own record label in a misguided attempt to salve his wounds. The plaintiff's complaint is utterly without merit and should be dismissed with prejudice. Oh, man. Shots fired already. What does UMG have to say about Drake? In the spring of 2024, two of the most popular recording artists in the world, Kendrick Lamar and Aubrey Drake, engaged in a high-profile rap battle. Over the course of approximately 2 months, they exchanged increasingly vitriolic, never seen that word before. I know vitriol, but vitriolic, good Lord, and incendiary diss tracks, in quotations, sometimes responding within hours of each other. Drake encouraged the feud. For example, When he felt that Lamar was taking too long to respond, Drake released the second recording where he said, drop, 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 drop. Y'all remember that? In which he goaded Kendrick Lamar to continue the public rap battle. He did. That was on Family Matters, right? I believe it was on Family Matters. Lamar did just that. And collectively, Drake and Lamar released a total of 9 tracks taking aim at each other, which is one of the great rap back and forth rap beefs of our generation. Let's be real. Multiple commentators declared Lamar to be the winner of the battle. I was one of those. Not Like Us, the track in the feud, or the arguable track in the feud, is the subject of the complaint. The recording and the music video were released by Lamar through defendant UMG on May 4th of last year. Not Like Us was a massive commercial and artistic success. The record was the best-selling rap recording of 2024 and won the Grammy for Record of the Year, and the accompanying music video won the Grammy Award for the Best Music Video. The song Not Like Us won the Grammy Award for Song of the Year and became an ambiguous cultural phenomenon, among other things. Lamar performed the song at the 2025 Super Bowl halftime show to a record audience, and Saturday Night Live parodied it in the recent 50th anniversary special. Not Like Us, like all recordings in the feud between Drake and Lamar, and like many notorious diss tracks throughout rap's history, consists of a series of hyperbolic insults. Okay. UMG, this is not the issue. So again, I don't know why they're starting this memorandum like this, because Drake made it clear. I don't care about Not Like Us. It's not about Not Like Us. Not Like Us was the tool. Not Like Us was the tool that UMG used to go after Drake. So that's why this song is being mentioned. It's not because of the songs. They're basically almost making Drake's point here by saying how successful the song was. It's like, yeah, the song was successful because you guys continued to push it and went out of your way to make sure that it's successful. And that's what Drake's point is. It's not about the song itself. In the lawsuit, again, we're not talking about Drake's feelings overall. We're talking about in the lawsuit, in Drake's initial lawsuit. The point is, UMG used Not Like Us, and they pushed it, and they pushed it, and they pushed it, and they pushed it. And now we are where we are. So we're going to keep going. We'll get into it, y'all. Hold on. So Drake has been pleased to use UMG's platform to promote tracks leveling similarly incendiary attacks at Lamar, including most significantly that Lamar engaged in domestic assault, and that one of Lamar's business partners and managers is the true father of Lamar's son. They make a good point there. And this is what I said at the beginning. Drake has been using and benefiting from this platform. So now you want to bite the hand that feeds you, in a sense. It's a fair point by UMG. But now, after losing the rap battle, Drake claims that Not Like Us is defamatory. It is not. While the complaint focuses almost entirely on Not Like Us, it disregards the other Drake and Kendrick Lamar diss tracks that surround it. Not Like Us, as well as the conventions on the diss track genre, and thus critically ignores the context of the dispute. I think that could be argued. Assessed in context, as it might be, Not Like Us clearly conveys non-actionable opinion and rhetorical hyperbole. Diss tracks are a popular and celebrated art form centered around outrageous insults, and they would be severely chilled if Drake's suit were permitted to proceed. Drake also alleges that Not Like Us constitutes second-degree harassment, but sues under a criminal statute that does not prescribe speech and has no private right of action. Finally, Drake's claim that UMG's promotion of Not Like Us, here's where I have an issue, violates the New York General Business Law 349, but fails to allege any of the elements for that claim. Well, we'll have to look at that law, because I think Drake talked about payola in this lawsuit. He talked about certain practices of discounting a royalty payment or discounting a licensing percentage to Spotify to push a certain song. But again, that's the system. Can you really complain about it? I don't know. Notably, less than 3 years ago, Drake himself signed a public petition criticizing the trend of prosecutors using artists' creative expression against them by treating rap lyrics as literal fact. See UMG's request for judicial notice. And then Drake recognized when it comes to rap, the final work is a product of the artist's vision and imagination. Drake was right then and is wrong now. Dang, UMG! The complaint's unjustified claims against UMG are no more than Drake's attempt to save face for his unsuccessful rap battle with Kendrick Lamar. My gosh. The court should grant UMG's motion to dismiss the complaint with prejudice. They say Drake is in his feelings, pun intended. Hey man, UMG is a little savage on this one. They said Drake had his feelings hurt. I think they're intentionally missing the point. The point being, Kendrick Lamar said certain things in Not Like Us that could hurt Drake. UMG then went out of their way to push this and to spin it to benefit them when it comes to negotiating their deal with Drake. Again, you want to say the defamation doesn't count. I might give you that one. But UMG, y'all do have some explaining to do when it comes to how you're promoting and pushing music. And I think that's one of the reasons there's so much pushback here. Because if not, they would let's just keep moving forward, right? That's not the case here. All right, what's their argument? We've got the legal standard here. To survive a motion to dismiss under Rule 12b-6, a complaint must plead enough facts to state a claim to relief that is plausible on its face. The court can credit only well-pleaded factual allegations and must disregard legal conclusions. In certain circumstances, the court may permissibly consider documents other than the complaint in ruling on a motion under Rule 12b-6. All right, such as documents incorporated into the complaint by reference and matters of which a court may take judicial notice. All right, so let's keep scrolling down and see what happened. Drake fails to state a claim for defamation. Y'all let me know if you agree. Drake, who had no concerns using UMG's platform to publish slurs about Kendrick Lamar during their rap feud, now claims that Not Like Us is defamatory. These allegations, which are directly aimed at chilling legitimate artistic expression, safeguarded by the First Amendment and the New York law, they say they're meritless. Here's the thing about this, though. If Kendrick Lamar has a problem with it, he can file a lawsuit, right? And if that happens, then I'm sure Drake would go down the path he has to go and see that through. One, I don't think Kendrick Lamar is going to do that. And two, that's not Drake's point. Drake's point is UMG used Not Like Us. It's not that Not Like Us, it has, it's the fact that it exists. It's the fact that UMG is like, hey, let's keep pushing this and let's encourage people to think Drake is guilty of certain things that he's not. And that's where he had the problem. UMG wasn't pushing the other songs. And I think that's where we're going to have an issue with this argument. Not like they push Not Like Us, obviously. Drake fails to state a claim for the defamation because Not Like Us conveys non-actionable opinions and rhetorical hyperbole, not fact, and because Drake cannot adequately allege that UMG acted with actual malice. That's going to be tough to prove. To succeed on his defamation claim, Drake must establish a defamatory statement and concerning the plaintiff, publication to a third party, falsity of the falsity of the defamatory statement, and special damages or per se accountability. And then they cite this case here. As here, the plaintiff is a public figure, he must prove that the alleged defamatory statement was made with actual malice. That is, made with knowledge of its falsity or with reckless disregard of whatever it was false. Okay. But the problem is Drake's not. This is why it's going to get weird. Because again, Drake made it clear he's not going against Not Like Us. He's not going against the company that created the gun. He's going against UMG for using the gun. The gun here is Not Like Us. And UMG, it pointed it at Drake and they said, let me get that discount on the next deal. So this is going to get interesting, and I want to hear their arguments on this, because did Kendrick Lamar make these false statements with malice or with reckless disregard of whatever is false? Obviously, because UMG, by their own admission, that's the nature of diss tracks and diss track culture. But does Drake have to prove that, or does he have to prove that UMG used this to defame him? So it's like secondhand defamation almost. Boy, this is going to be weird. Because again, he's not going against Not Like Us. He's going against UMG's use of the song. Boy, this is interesting. The alleged defamatory material is non-actionable opinion and rhetorical hyperbole. To be defamatory, a publication must convey fact, not opinion or rhetorical hyperbole. No. Because if that's the case, A$AP Rocky wouldn't have a lawsuit either. Expressions of opinion, as opposed to assertions of fact, are deemed privileged and, no matter how offensive, cannot be the subject of an action for defamation. Whether a statement is fact or opinion is a question of law for the court. To distinguish assertions of fact from non-actionable opinion, New York courts analyze that whether the specific language is issue has a precise meaning which is readily understood, whether the statements are capable of being proven true or false, and whether either the full context of the communication in which the statement appears or the broader context and surrounding circumstances are such as to signal readers or listeners that what is being read or heard is likely to be opinion, not fact. Interesting. How would you interpret the music? We're bringing music back into it again, I think. At its crux, the question for the court to resolve as a matter of law is what a reasonable person hearing or reading the statement would take it to mean. I mean, I think most people are saying that Drake is a PDF. And they're out here saying, yeah, I think Drake's a PDF. He did it. Just look at what he's doing. Oh, he took a picture with that young person. I think he did it. I don't know. Are they going to use that as evidence moving forward? Some YouTube videos might be brought up in this lawsuit. In this assessment, context is key. The Court of Appeals of New York has consistently focused its analysis on the overall context in which the complaint of assertions were made. This includes both the immediate context in which the dispute would appear, as well as the larger context in which the statements were published, including the nature of the particular forum. And then a statement's tone and apparent purpose may signal that it is not conveying an accurate factual assessment offered by a disinterested observer. You know what? I think we need to bring back Detective Super Investigator Viverito for this, because we need a diss track expert. And I think she could probably qualify for that. So we'll have to do some research and see if that's in her field of expertise, because we're going to need a diss track expert to really analyze the tone and apparent purpose of this track. Was it to obliterate and destroy? Do we go back to some of the other Kendrick Lamar diss tracks to where he says, don't tell any lies about me, and I won't tell any truths about you? Oh. I mean, we really need to get a diss track expert on this. This is going to be a tough one. For example, tone may indicate non-actionable opinion where it reflects a degree of anger and resentment, where the tenor is rambling, heated, or speculative, or often escalates into hyperbolic, or where a statement invokes parody, loose, or figurative language. Likewise, the broader context informs whether a statement is reasonably understood to convey factual assertions. Even apparent statements to the fact may assume the character of a statement opinion. When made in public debate, heated labor dispute, or circumstances in which an audience may anticipate the use of epithets, fierce, fiery rhetoric, or hyperbole. Okay, so this may apply here. It seems like it would apply to diss tracks. Let's keep moving. Let's see here. Consistent with that observation, New York courts routinely hold that tone and context render allegedly defamatory publications non-actionable. So it might not apply here. I think that's up for interpretation. The recent case of Rappaport versus Barstool Sports is particularly instructive. There, actor Michael Rappaport alleged that statements by Barstool Sports accusing him of having an STI and assaulting his ex-girlfriend, including several statements in a 6-minute diss track in which defendants assaulted a constant stream. Rapped a constant stream of insults and slurs about Rappaport against a backdrop of unflattering video clips and images were defamatory. So he lost that one. Interesting. The district court judge rejected the claim as a matter of law. The statements were largely laden with epithets, vulgaries, hyperbole, and non-literal language and imagery, delivered in the midst of a public and very acrimonious dispute between the Barstool defendants and Rappaport that would have been obvious to even the most casual observer, and published on social media, blogs, and sports talk radio, which are all platforms where audiences reasonably anticipate hearing opinionated statements. So they're saying nobody would basically look at this and believe that Drake's a PDF. Nobody would look at this and believe that Kendrick Lamar put his hands on Whitney. Nobody would look at this and think such and such. So with that being said, I have to keep saying it. That's not the main issue. The main issue is their promotion and their constant pushing of the track. It's going to be a tough battle for Drake, I think, on this one. But I think he still has a case here. It'll be interesting to see how this is interpreted by the judge and if the judge thinks it applies here. Because in this case, it was Barstool Sports versus Michael Rappaport, right? Now, in this instance, we have a third party. Drake is saying, leave Kendrick Lamar out of it. UMG, you're the problem. You're the issue. I don't know. The Second Circuit affirmed in Rappaport in 2024, holding that the district court appropriately considered that the statements at issue were made in the context of a hostile, vulgar, and hyperbolic feud, in which the use of vulgaries and hyperbole function as a strong indicator to the reasonable reader that the statement is not expressing or implying any facts. Again, I mentioned Kendrick Lamar's quote about don't tell any lies about me and I won't tell any truths about you. I can guarantee y'all that if this goes forward, that's going to be brought up by Drake's camp. Because in that instance, is him saying, don't tell lies about me and I won't tell truths about you, is that hyperbole? Or can that be taken as true? And then moving forward after that point, everything that Kendrick Lamar said after that is supposed to be taken as facts? Looking first to its tone, the 4.5 minute rap diss track consists of a series of fiery rhetoric and hyperbole. And not surprisingly, given the context, the record reflects a considerable degree of anger and resentment. And exaggerated vitriolic words pervade the recording to attack all aspects of Drake's life, including his career, authenticity, brand, relationships, and character. Exaggerated imagery in the music video enforces that Not Like Us is not intended to reflect a factual analysis. For example, the video opens with Kendrick Lamar whispering to a song that he sees dead people, a nod to the film The Sixth Sense, implying hyperbolically that Drake has been defeated in a rap battle. The video also shows Lamar beating an owl piñata with the disclaimer, no OV hoes were during the making of this video. Oh, man. And staring down the owl in the cage. This imagery enforces the non-factual nature of Not Like Us. Indeed, no reasonable listener would require a disclaimer that the piñata is not literally Drake and his crew. The imagery is satirical and vitriolic, all of which signals to the audience that the video does not convey sober factual analysis. I think the issue from that is Drake's house was shot up. People broke into his house after this, so they're going to have a problem there. Again, I still think Drake has a case, and Not Like Us isn't really the issue, but I get what they're saying. Likewise, the album's image of Drake's Toronto house, which is probably going to be a problem, is obviously doctored, further underscoring the non-factual nature of Not Like Us. Again, no reasonable viewer would believe that the image of Drake's Toronto mansion with 13 offender markers is real. I don't know about that one. The image is hyperbolic and exaggerated, conveying opinion, not fact. Dang. The broader context also reinforces that Not Like Us is non-actionable. Not Like Us did not emerge out of thin air. It was Lamar's culminating diss track in one of the nastiest lyrical warfare rap feuds in recent history. It followed the release of 7 preceding tracks in which Drake and Lamar hurled increasingly vitriolic allegations at each other, including Drake's slurs that Lamar's son was fathered by someone else, Dave Freeze, and that Lamar cheats on and physically abuses his fiance. Oh, man. If ever there was circumstance for the evidence to anticipate the use of epithets, fiery rhetoric, and hyperbole, this is it. Moreover, assessments of the broader context makes clear that Not Like Us relates to well-known controversies that Drake himself acknowledged and perpetuated. They might have a point there. And facts and criticism concerning Drake's relationship with minors predate Not Like Us and have been widely reported. Oh, dang. Come on, UMG. Y'all gave this man almost $500 million. Don't do that. They didn't say criticism. They didn't say rumors. They didn't say, oh, well, the grapevine says. They said facts and criticism concerning Drake's relationship with minors predate Not Like Us and have been widely reported. Oh, man. Why'd y'all say it like that, UMG? That's kind of dirty. Noting that Lamar is indicating Drake for the years of rumors and speculations around his misbehavior around minors, and that Millie Bobby Brown, here we go, is one of the things that most people are aware of when it comes to Drake and the rumors around him. She talked about texting with Drake when she was, a minor. Notably, Drake himself called on Lamar to invoke the allegations in Tailor Made Freestyle, released before Not Like Us, in which he said he had Tupac's AI-generated voice rap that Lamar should talk about Drake liking young girls. In the Heart Part 6, which was absolute trash, Drake, I'm sorry. Drake also affirmed that he understood Lamar's statements in Not Like Us to refer to the Millie Bobby Brown controversy, stating, "This Epstein angle was the ish I expected, and only effing Whitney's not not Millie Bobby Brown's. I never looked twice at no teenager. Clearly, Drake, that was the weakest. The Heart Part 6 was terrible. Clearly, Drake himself understands that Lamar's lyrics refer solely to well-known issues. Taken together with the fact that Not Like Us was released in the context of a combative, vitriolic rap diss battle, it would be obvious to even the most casual observer that Not Like Us is not an accurate, factual assessment offered by a disinterested observer. In sum, the tone and broader context in which Not Like Us was released makes plain that the recording, video, and album cover convey rhetorical hyperbole and opinion not based on anything beyond controversies that have been widely acknowledged, including Drake himself. Drake fails to state an actionable claim for defamation. Also, Drake cannot allege that UMG acted with actual malice. This is going to be interesting. Drake's defamation claim fails for the independent reason that, as a matter of law, he cannot allege that UMG acted with actual malice. A public figure can only prevail on a defamation claim where clear and convincing evidence proves that a false and defamatory statement published was published with actual malice. That is, with deliberate or reckless falsification. The element of actual malice in a defamation claim focuses primarily on what a defendant knew or believed at the time a purportedly false statement was made. Interesting. And of course, UMG is going to defend themselves here, and they're going to say, to survive a motion to dismiss, a defamation plaintiff must allege specific facts that plausibly evidence actual malice in a clear and convincing manner. Courts recognize that in certain circumstances, such as works of fiction, parody, and satire, the actual malice inquiry must focus on what the publisher subjectively intended to convey. For example, well, I think that's what Drake wants some of this discovery for, but we'll hear their response at some point. For example, where the speaker intends his statements as outrageous parodies or caricatures, there may be no consciousness that the speaker is publishing something false because the speaker does not think he is publishing a statement of fact and therefore lacks subjective knowledge of recklessness as to the falsification of a statement of fact required to show actual malice. So what's your defense here, UMG? So to here, there is no basis for a claim that any person at UMG had the subjective intent to publish false factual statement about Drake. UMG released a rap diss track conveying fiery rhetoric and insults, not factual assessments, much less false ones. UMG engaged in the same conduct when it distributed Drake's Family Matters, in which Drake rapped that Lamar engages in domestic abuse, is not the father of his son. Much like parody and satire, hyperbole, exaggeration, and insults are endemic in rap, particularly in diss tracks. Rappers know that their lyrics are exaggerated and non-factual. That is part of the craft. So are they going to have to get a statement from Kendrick Lamar saying that? Or are they just basing it on previous case law? That's what it sounds like here, but I can't imagine Kendrick would come out and say, he's not really a PDF. I was just kidding, guys. I don't think so. And Mo is saying, I didn't hear rumors until that song. Well, you need to call over the OVO headquarters and let them know that, and they might use you as a witness. Rappers know that their lyrics are exaggerated and non-factual. That is a part of the craft. The actual malice question is therefore what UMG intended to convey. And Drake has not alleged any specific facts plausibly evidencing in clear and convincing manner that anyone at UMG intended to convey or indeed believe that the public would understand Not Like Us as conveying anything other than what it was, an incendiary diss track. UMG, no. And again, this is where I think the YouTube videos are going to come out. You're going to see a lot of content creators. Yeah, this is going to be a tough one. This is going to be a tough one. You're going to see a lot of content creators that were mentioned before reviewing the videos. And if they were allegedly paid and asked to do these reviews, then that's going to be a problem. Especially if they sit there and point out and say, oh, this is actually where he's talking about this. Oh, he might actually be talking about Millie Bobby Brown. What does he mean by that? So it might be an intention there. We'll have to wait and see what they say. And we're not going to get into the harassment here. I'm going to leave it there for now. I'll be posting this full document over on the Patreon, so y'all can go check it out there. And I might even break this down a little bit further over on the Patreon as well. But let me know what y'all think about this in the comments and in the chat. Does Drake still have a case here? Is this a decent response from UMG? And would a judge rule in their favor? And what do you think Drake is going to say in response to this? I guess we'll have to wait and see. And shout out to the gang. Man, I hope this goes to trial. I hope this goes forward. Or at least we get oral arguments, because I want to hear what they have to say. Let me see what y'all are saying about this. Yeah, we need a diss track expert to come up here. Money Wins court case is not the truth. UMG is saying that Kendrick didn't say anything that wasn't already rumored about Drake. He did what was already known publicly about Drake. Yeah, that's a good point. But there was some, well, I'm not going to go back and get into it, but that is a good point. The music industry will destroy artists once someone doesn't go along with the process. That's true. People were always saying stuff like that before the song, including Drake himself. Yeah, I knew about Drake following around high school basketball players since the early 2010s. He's a PDF. I don't know about that one. When Drake's your friend, he'll watch out. Yeah, no one is going to take it literally and believes the one dissing him has seen his actual medical records. I forgot about the... Yeah, I didn't even see that with Michael Rappaport. That's crazy. He is nonstop talking smack. Yeah, UMG is wow. How is the main issue when it's a defamation? How is that the main issue when it's a defamation lawsuit? Didn't he drop the payola claims and only proceeded with the defamation lawsuit? So Drake did not drop the payola claims. He just dropped iHeartMedia and Spotify from the lawsuit. UMG can still be held accountable for that. UMG could stop Drake from releasing anything for at least 2 more years. I hope they put him on ice and end his career. Dang, why? Do y'all not like Drake that much, or you just don't like his music? Only Canadians and at-risk youth still listen to him anyways.
Stop the cap.
No, that's not true. Drake makes some good music. Let's separate the two. Y'all gotta get out your feelings now. Dang. His house was shot at by the Weeknd's camp, y'all think? I'm worried about the new level of censorship that could come from this. And I think that's what a lot of people are saying. And while they're saying Drake isn't for the culture because he's taking, it appears to some that he's taking a shot at rap music. I don't see it that way. I think I see the bigger picture, and I see what Drake is trying to say from this lawsuit. He's trying to say UMG used this as a pawn. They used Not Like Us as a pawn to diminish the value of his brand, and therefore get a discounted deal when they go to re-sign him. And Drake seems to say he has the facts to back it up. So we'll have to wait and see. Kendrick should have called him a minor attractive person. Jeez. Mo said, I didn't hear the rumors until that song. iHeartRadio already exposed UMG. It's why they backed out the lawsuit. Yeah, Drake, he might have gotten what he needed from them. So I'm confused. Didn't he drop the other defendants, and this lawsuit is strictly defamation from the result of Not Like Us? UMG Cook, they already got exposed by iHeartMedia for payola. UMG has a lot more since he wants to see is what I think he meant to say. Yeah, for sure. All right. Oh, there's so much more to get into there. And if y'all want to check out this full document, I'm going to I'll put the link in the description and the Patreon too. And the conclusion was short too. For all the foregoing reasons, the plaintiff's complaint should be dismissed with prejudice. The end. Shout out to UMG, man. All right, let's go ahead and get back into Jason Levesque, man. See what's going on with this trial. We got some more testimony. Today is going to get a little weird. I didn't watch this entire trial because I want to react to it live with y'all. But I've never seen a support animal brought onto the witness stand. So we're going to have that for the first time today. This is going to be interesting. What do y'all think? If y'all were following the Drake and Kendrick Lamar rap beef battle, whatever you want to call it, which song was your favorite song out of that? Y'all let me know which one. And I guess that would depend on where you think the beef started. Did it start with oh gosh, I can't think of the song that Kendrick Lamar didn't get on with J. Cole and Drake. What's the name of that song? Oh, it's gonna come to me. Anyway, let me know what y'all think. Says I'm not a Drake fan, and Not Like Us was my most listened song. Euphoria. Yeah, I think Family Matters was good. Euphoria was really good. Mr. Brown's in the building. Shout out to Mr. Brown. Good to see you in here, man. Don't ask me how I'm doing. How are you doing, Mr. Brown? This man is recovering from open heart surgery. Y'all make sure you say a prayer for him and keep in your prayers as he's recovering. Thank you for being here, man. Euphoria was on repeat, but then Not Like Us came out so fast. Yep. I thought Push-Ups was really good. Push-Ups was good. Euphoria was good. I like the beat on Meet the Grams, but I don't like the song itself. I thought it was a little too much. And Mr. Brown said he's in rehab. Rest up, Mr. Brown. Take it easy over there, all right? All right, so let's go ahead and get back into trial. So yesterday, or on day 2, we got to hear from some of the police officers that responded to the scene. We got to hear from an amazing officer that not only responded to the scene, but administered first aid to Kyle. And then they were able to get him to the hospital. We saw a testimony from one of the paramedics as well. Now we're going to get back into more witness testimony. We're going to hear from the military veteran that actually was the first one to get to Kyle and kind of help him when he saw him laying on the ground. And then we're actually going to hear from another witness that's going to be interesting here moving forward. So y'all let me know what you think about this and make sure you like the video on your way in. Here we go.
To the left of the judge. And if you could approach kind of around the corner there, face the judge, and remain standing for your oath.
All right. Good morning, sir. Will you raise your right hand? Do you swear any testimony you're about to give will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury? You may be seated. Just please keep your voice up so everyone can hear you. Counsel, you may inquire.
Thanks, sir. Can you state your name and spell your name for the court record?
Sure. John Freest. Last name is Freese.
And what do you do for work?
I'm an emergency physician.
Where?
At Buzbee Memorial Hospital primarily, but also hospitals in New Hampshire and Virginia.
Understood. Can you give the jury just a brief summation of your professional training and experience?
I've been an emergency physician for 25 years. I trained at Indianapolis, the Indiana University Emergency Medicine program back in 2000. When I graduated from there, I did my postdoctoral fellowship in EMS, or emergency medical services, at the New York City Fire Department.
Nice.
Spent 10 years as a medical director with the fire department, was chief medical director, and oversaw all the ambulances in New York City for that decade, during which time I also worked clinically. And then for the last 12 years, I've been primarily here in New Hampshire and now also Virginia.
Thank you. I think that suffices. Look, do you remember, with the benefit perhaps of reviewing some records, treating a patient named Kyle Violet?
Yes.
And my understanding, if I could just briefly summarize, you saw him, but he then was transferred to 2 other hospitals.
That's correct.
You know, given the nature of his injuries, can you just give us a thumbnail, an estimate of how many physicians do you think treated him over the course of his 3 admissions to various hospitals?
It was dozens.
And so I'll cut to the chase. You know, by agreement with Attorney Sisti, we've asked you to kind of come in and summarize the treatment evaluations from each 3 of the hospitals, so that we don't bring in dozens of physicians. Is that how you understood your testimony today?
It is.
And have you had the benefit then of reviewing treatment notes, summaries and image notes from the other hospitals?
Yes, I have.
And based on your training and experience, notwithstanding the fact that you didn't actually do the treatment down in Boston, do you feel comfortable sharing with the jury a summary and an explanation of the treatment and injuries?
I do.
Great. Then let's get started.
And just so the record's clear, this is without objection, correct?
No, this is actually an agreement we made like a week ago. So
Very good. Just
let's go.
wanted the record clear. Thank you. Continue.
To understand, it could take days to talk to 13, 14 different...
Of course, the court understands. I just wanted the record clear. Just wanted the record clear.
Dr. Fries, do you recall when Mr. Violet was admitted?
It was April 4th of 2022.
And I'm going to refer you to my reference note of page 427. Actually, this may be faster if I approach, Your Honor.
Of course, please.
Can you share with the jury, you said he was admitted to what facility?
Initially to Frisbee, and I misspoke. I said 2022. It was 2024.
In the past. Okay, so do you recall the time when he was admitted and discharged?
He was admitted to Frisbee at...
Counsel, I'm referring to page 427 of the notes. I'll direct your attention to the 4th paragraph.
At 10:30 p.m.
And then can you indicate when he was discharged?
Yeah, at 11:13.
So about 45 minutes he's at Frisbee, correct?
That's correct.
And if you could summarize the evaluation, the injury notes, the triaging notes from his arrival at Frisbee. How did he appear to you?
So when he arrived, he was anxious. He was pale. He was confused, as most people are when their blood pressure is critically low, as his was.
Yeah, I can imagine.
His initial evaluation demonstrated a number of gunshot wounds, and his initial treatment for stabilization, given his very low blood pressure and the severity of his wounds, was to secure his airway. So he was paralyzed, sedated, and intubated or placed on a ventilator. He had a cordis introducer placed, which is a very large IV catheter that was placed into his femoral artery to allow for the rapid administration of blood products. And he had a chest tube placed, a large tube that goes into the chest cavity to allow his left lung to re-expand.
Very well. I'm going to direct your
Yikes,
attention
he was
to,
messed up.
Our discovery note of 446 should be on the bottom right-hand page of your notes.
Okay.
There appears to be an admission summary. Can you indicate the number of gunshot wounds that Frisbee was able to identify?
It appeared to be a total of 6 gunshot wounds.
And can you briefly describe them to the jury?
Sure, there were 2 to the left chest. One was just below the clavicle. One was over the left lateral chest wall. One was to the lower abdomen, which was just inside of the hip bone, the front of your hip here. The next was to the left hemiscrotum, so just adjacent to the penis and somewhat involving the penis and the scrotum. And then there was one to each buttock.
You would describe that the pelvic, the abdominal wound was anterior. That's actually on the front side.
Correct.
Okay, and behind that was a gunshot wound to his left buttock. Is that correct?
Correct.
This goes on to indicate the sort of the level of concern. What was the?
It's a lot of times to get
his,
shot.
Condition.
He was critically ill.
And would you consider critically ill to be life-threatening?
Imminently.
And so you had made some additional notes that I don't understand. The patient was notably, and can you share that word, tachycardic?
The patient was notably tachycardic or had an elevated heart rate and markedly hypotensive, meaning his blood pressure was incredibly low, with an initial systolic blood pressure in the 50s.
And then what did you do in response to that, if anything?
So, as mentioned, he had the cordis introducer placed, which was the large bore IV. He had 2 units of blood that were initially ordered. The intubation, placing him on the ventilator, like I mentioned, and then immediately after the intubation and placing him on a ventilator, the tube thoracostomy, or the chest tube, was placed in his left chest.
I noticed that the notation uses the term a massive transfusion protocol. What is that?
Most hospitals have a transfusion protocol that requires the administration of multiple blood products in the case of a critically ill patient who appears to have significant bleeding. So it includes the administration of not only red blood cells, but also products to help to replace the factors that allow you to form a blood clot, so that you have all aspects of your blood being replaced.
There's a notation on 427 that indicates at 2240, PRCP Unit 1 and then Unit 2 both transfused within 10 minutes. Is that notable to you?
Yes, it's a rapid infusion, as we would expect for a critically ill trauma patient.
And so after making these assessments, what do you actually do at Brisbane Memorial?
So like most smaller hospitals or critical access hospitals, the role of a smaller hospital is to stabilize the patient so that they're able to survive transfer to a tertiary facility or a higher level of care, or in this case, 2 higher levels of care. So our goal was to maintain his blood pressure, maintain his airway, improve his breathing, get in touch with a trauma surgeon at a local hospital, in this case Portsmouth. And move in there
right,
as
she's
rapidly as
right.
possible.
And did they agree to receive
That's a
this
fact.
patient, Mr. Vile, at the Portsmouth Hospital?
They did. Dr. Cromer accepted the patient.
In fact, was this situation so acute that you essentially held off on doing other diagnostics that you would have normally done?
Yes, and that's standard for someone who's this critically injured.
And so you've indicated to us that at 23:13, he actually left for Portsmouth.
Correct.
And I want to then turn your attention to the documents that appear to be generated from Portsmouth, which begin at 468 of our discovery.
Okay.
What I first see is what appears to be a summary of a CT scan report.
Yes.
And can you please explain the observations or the diagnostics that are referred on 469, the following page concerning stomach and bowel?
With regard to stomach and bowel, there were a few punctate metallic foreign bodies within the lumen of the stomach, which were felt to represent bullet fragments that had been swallowed by the patient. There were no evidence of any bowel injury on the CT scan itself.
And so at this point, they hadn't yet diagnosed perforation of his bowel that was eventually they performed surgery on.
Correct.
Can you?
That could have been
return
really
then
bad
to
if they didn't
the,
catch it.
Give us a summary of the findings for his lungs.
For his lungs, there was the chest tube that we had placed at Buzbee that terminated near the lung apex or at the top of the lung. There was fluid within the chest tube itself, which was the blood that was coming from that tube. And there was a small left-sided hemopneumothorax, which is a combination of blood and air that remained in the chest even after re-expansion of the lung with that chest tube.
There's a heading called osseous and soft tissue chest. Can you summarize those findings?
The radiologist noted that there were several small metallic fragments in the left pectoralis muscle or the left chest muscle here, that there was a larger metallic fragment that was just in front of or anterior to the first rib, and then subcutaneous air or air beneath the skin that would be expected after someone had both gunshot wounds to the chest and a chest tube placed.
Look, in that area that we're talking about, can you share with us whether there are either critical nerve, veins, arteries, other organs that you would be concerned about for major trauma in that particular area?
Yes, everything that keeps you alive sits right there. Your heart is just to the left of your sternum primarily. The aorta, which is the artery that carries all of your blood to all of your body, leaves the heart and curves to the left and descends, as well as going up through your carotid arteries. The lung, obviously, and in this case, the artery that surrounds each one of your ribs, which by itself can also be a life-threatening injury.
This report has a heading called reproductive. Can you just briefly share with us the observations and diagnostics?
Yeah, they note that there is some subcutaneous air, so again, air beneath the skin within the left hemiscrotum or the left half of the scrotum. They were able to describe this as an entry wound that was adjacent to the left base of the penis, and then some small metallic foreign bodies beneath the skin that were noted, as well as several smaller metallic foreign bodies within the scrotum itself. And they were not able to visualize in this study the patient's left testicle.
Understood.
I mean, Kyle's lucky to be alive.
There is a
Seriously.
notation at looks like 469 that concerning the, again, this is soft tissue, tissue structures. Quote, there appears to be a potential exit wound at the skin surface of the anterior left lower quadrant of the abdomen.
Yes.
Just want to show you, if I may approach your arm.
Of course.
Counsel, these are the photos. All right, very good.
Your Honor, these are full exhibits, and I have no objection.
Very good. The record will so reflect these are full exhibits.
I'm going to show you what's been marked as Stage 19, and just ask if you could explain kind of what you see.
So this is, by definition, a critically ill patient, as evidenced by the fact that they're on a ventilator. The patient has appears to
on a
be his
ventilator,
left
too.
chest tube still in
Dang.
place, from what I can see from the lines. He has an oral gastric tube in place, which is a tube that drains the stomach of the gastric contents, the stomach contents that you produce every day, even if you don't eat, and multiple monitors.
I had originally asked you about the observation or the state describing an exit wound in the abdomen. I'm going to show you stage 21 and ask if that is consistent with the evaluation that was written.
It would appear to match.
And as an exit wound, does it make sense that that would correlate with what I'm going to show you in stage exhibit 23? Which, if you could just describe that to the jury.
So this is a wound that appears to be on the high portion of the left buttock, relatively large in size, and with no surrounding skin changes.
And if that were the entry wound, would that make sense to you that way that the abdominal wound was back the texting?
It certainly could be.
And so the image that we see in 21, while located kind of on the front of the body, was actually inflicted from behind it.
Yes, it appears so.
Do you recall evaluating initially the gunshot wound to his face?
Yes, I do.
And I'm going to show you stage 20 and ask if you can identify that and describe it.
I guess you don't forget a victim like that.
Yes, this appeared to be a gunshot wound or penetrating wounds to the jaw or the mandible that was just beneath the jawbone of the mandible here on the side of the neck.
And do you recall the consequences as a result of that particular gunshot?
It appeared that he had significant intraoral injuries as well. And I recall from the note being able to even palpate bullet fragments in the area of the jaw.
Dang.
And, once again, now in this area of the body, can you just tell us whether or not there are critical nerve one and other potential organs very close to that?
Yeah, this is very close to your carotid artery, the main artery that sits here that feeds essentially one half of your brain. An injury to that, like most major arteries, is one you can bleed to death from within 2 to 5 minutes. And if the bullet continued further than that, you have the spinal cord and the brainstem, which allow you to live.
Dang.
At Buzbee, you can confirm that you deferred some analysis, and that includes CT scan. So is it true that you did not see the dissected portion of the carotid?
That's correct.
There is a brief summary on 492, if I could refer you before he is then passed on to Boston Medical Center. And at the bottom there, it seems to be a paragraph. Can you confirm that at Portsmouth they were required to provide massive transfusion, continued there?
Yes, it did.
And that the injuries were consistent with what was observed at Portsmouth, but here at Buzbee, but they add here that they now have observed an external carotid injury, complicated mandibular fracture, pulmonary hemorrhaging, and again, make note of the significance of the external carotid injury. Can you just briefly describe for the jury what they're talking about?
Yeah, so what they found on the CT scans that were performed there was that the carotid artery, which comes up your neck and then splits into the internal carotid artery that goes to your brain and the external carotid artery that goes to your face. The external carotid artery had a sudden occlusion near its origin from the common carotid artery, so it appeared that the bullet had transected that artery.
What do you mean by transected?
Or had cut in half and
Ouch.
caused the blood flow in that artery to stop.
All right, so I'm good on the doc, man. We're gonna go ahead and skip ahead to. Oh, this is gonna be interesting. We're gonna skip ahead to Jason's daughter. We're gonna get this in a second. This is going to be a very, very interesting testimony. So y'all get ready for this one. I want to see what y'all are saying in the chat, though. I wonder if Kyle was armed and his family members hid the gun before calling the cops. I don't think they had time because there was someone that responded and got to Kyle almost immediately. We haven't heard from him yet, though. In Texas, you just assume you'll be shot if you run onto someone's property making threats. I don't think they'd brought charges if this happened here. The guy lost a nut also.
Hey, yo.
He did. Hope it was worth it. All right, here we go. We're going to get into the testimony from Jason's daughter. Y'all get ready for this. This is going to be an interesting testimony. Here we go.
I'm going to walk right up to the witness stand. And if you could just remain standing facing the for your oath.
Can you raise your right hand? You swear that any testimony you're about to give is the truth, the whole truth, and nothing but the truth, under the faith and penalty of perjury.
I do.
All right. You can be seated right here. Make yourself comfortable. Just asking you to scoot up as close to the microphone as you can and keep your voice up so people can hear you, okay?
Okay.
And whenever you're ready and whenever counsel is ready, you may inquire.
She has emotional support, Rabbit.
Good.
Oh, y'all see this?
Can you begin just
This
by
is
saying
crazy.
your full name and spelling your name for the court reporter, please?
Kira Levesque, Kiralevesque.
And, you know, I want to be sensitive about some privacy issues, so I'm not going to ask about current, but I'd like to go back to...
This is wild. I've never
April
seen this
of last year
before.
and ask you where you were living on April 4th of 2024.
41 Summer Street.
Who'd you live there with?
My dad and my grandparents live downstairs.
Who were the neighbors, as you know?
Kyle and Angela.
Let's move directly into the 4th. What were you doing earlier in the day?
Have y'all ever seen this?
Or earlier in the evening of the 4th?
I was working.
And was that in Rochester?
Yes.
How'd you get home?
My dad picked me up from work.
And what did he pick you up in?
A plow truck.
It's probably
Was your
emotional
dad,
support,
doing
Rabbit.
plowing as a job at that time?
He was.
And can you then describe for us what happened initially, right when you got home?
We got home and we just started plowing our driveway like normal during a storm.
And you say plowing the driveway, then this was, I think we've all heard this, we've seen some photos and video, whatever, it's snowing pretty good, right?
Yeah.
And
Wow, she was
can
with
you just
him
describe
when this
the
happened?
sequence of
Dang.
events in plowing as you recall it?
We got home, we were plowing like down towards into our driveway, and we were doing that for a couple minutes, and then he switched around so we could get like coming towards like the opposite end of the street, and we're plowing it like into our porch.
And so let me just clarify, you lived in 41,
Yep.
The Violets lived in 43,
Yep.
and when you originally described plowing towards your driveway, you're talking about plowing at an angle across 41,
Yes.
and then turned around and went towards 43.
Yes.
You know, without getting into too much detail, were you aware of some prior, even if you want to call them incidents or however you want to characterize it, between your dad and Mr. Violet about the snow situation?
No.
You had
Dang.
previously talked about a snowstorm the previous year. You recall that?
No.
So, Kara, I want to be, just fair with you that this event is now, a year old. I'm going to guess that there are parts of this you actually try not to remember.
Yes.
Is that true?
Yes.
But Do you remember making a statement that very night of the 4th, maybe into the 5th, down at the police station?
Yes.
Well, we're skipping
You
to
were
the police
informed that it
station.
was being recorded?
Yes.
And so I actually have a transcript that is a written version of that statement.
Okay.
And my question to you is whether or not seeing, reading aspects of that transcript might help your memory.
I'll look at it.
Okay. Pardon me?
Would you like to ask me to approach counsel?
Yeah, just for a second.
So the defense is arguing about what's being brought in, the transcript. I don't see a big deal here, but I'm also not a lawyer. Shout out to Mel. Let's keep it moving.
Between your dad and Kyle about where the snow is going between the properties. Remember any of that?
No.
And then I had referred to a prior statement that night that you had made, and just asking if it would refresh your memory. Seeing it. Council page 19. Line 20. I wonder if you could just read this.
I can't see that.
Yeah, you can take it. Well, this whole paragraph you can read yourself. Let me know if that helps you remember.
Okay.
Does that help?
I don't remember that.
She said, nope, it sure doesn't.
But when police officers asked last year about
Rabbit looks
any
happy.
fire or snowstorm incidents, you did answer them. You said last winter there was this kind of conversation between Kyle and Jason, right?
Okay.
Well, those are your words, not mine, right?
Yes.
And you told the officers, yeah, I mean, there was this incident where Kyle was moving snow and it went onto your property, and your dad told Jason, Kyle, not to move it there, right?
Okay.
But you say, okay, those were your
I mean, if
words,
I
right?
said it, then yeah, I just don't remember.
Okay, that's fair. But you'd agree with me, these are your words.
Yes.
And you also went on to talk about a snowstorm, the first snowstorm of 2024. And that's
That
right
still
here.
doesn't make what he did right.
Okay.
Does that help your memory?
I mean, I don't remember, but
But you told the investigators that,
She says she don't remember. She don't remember. He's like, you sure you don't remember? All right, get it together, prosecutor.
no.
Here we go.
All right, you may be seated, ma'am. Counsel, you ready to proceed?
I am.
So management happens to ask you a series of questions about the land, about that are designed to determine whether certain documents. So, just getting answer their question.
I think you said you remember going to the police department the night of the 4th into the 5th.
Yes.
And were you aware of
Oh, the jury's
really
not
the
in.
importance of being truthful,
Interesting.
complete, and honest when you were talking to the police?
Yes.
And looking back, do you feel like you were truthful, complete, and honest with the police when you made your statement about or answered their questions about background and what had happened?
Yes.
And do you feel like you had a better memory of events last year, the 4th, going into the 5th,
Yes.
of events and the issues I've asked you about.
Yes.
Do you feel like your memory now isn't quite as good?
No, it's not.
And can you even remember making certain specific statements, that, for instance, that I've showed you?
No.
Yet, a year ago, do you believe they were
Interesting.
complete, accurate, and honest?
Yes.
Thank you. Councilman, political part?
Thanks.
Hi, Mark.
Did the police offer you the opportunity to review your statement at all?
I don't believe so, but I don't remember.
And can you tell the judge when this statement would have been made relative to the shooting?
Maybe within the hour after. It was definitely that night.
So it was very quickly afterwards?
I want to say they had me in the back of a cruiser at the house for maybe a half an hour. I'm not really sure. I didn't have my phone out. It was kind of just all a blur and a rush of things, but it was that night.
Okay. And can you tell the judge what you thought your mental condition was then? What was your emotional condition?
I obviously was very shaken up. I was
Yeah, I can
in
imagine.
kind of just like fight or flight. I was in a very high state of anxiety. My best friend was upstairs, so I was worried that she was going to worry that I was hurt. I obviously was concerned what was happening with my father.
Dang.
I wasn't very focused. I was very high anxiety.
And I don't want to delve into too much either, but I mean, you're sitting there with a comfort animal right now.
Yes.
Oh, it is a comfort
And why is
rabbit.
that?
Due to my anxiety.
And were you suffering from such a condition back then?
Yes.
And
Yeah,
that
the rabbit
on
looks
top of the
happy.
shooting, I mean, did that combine to affect, you think, your recollection and accuracy of events at the time?
One more time?
Yes, could that have affected your accuracy of the events at the time?
When I gave my statement, I'm sorry, I don't understand what you're asking.
Yeah, I mean, we're being asked now, you're being asked, let's go right to it, about some kind of a plowing incident or something like that, some preceding plowing incident.
Okay.
Right. Do you actually have a recollection of that at all?
I remember giving my statement, but I don't remember that event in my statement.
You don't even remember that event in your statement?
No.
And again, this is a statement that you weren't given the opportunity to review, alter, or modify in any way, shape, or form.
I don't believe they gave me the opportunity now.
You never told them that what was in the statement, you reviewed it and it's accurate and that's exactly what happened. Did you ever tell the police that?
No.
Did you ever sit down with a representative of the state of New Hampshire, the county of Stratford, and say, I've reviewed my statement, I've listened to the audio and everything in it is true and accurate?
No.
So this is the first time you've given that opportunity?
Yes.
Interesting.
And after even listening to that, and after what we've just gone through, you still don't recollect any kind of a plowing incident prior to this?
No.
Sure of that?
Yes.
Thank you.
So they're putting in work on our memory.
You've had, as I understand it, an anxiety issue for quite some time.
Yes.
Your anxiety issue doesn't cause you to, for instance, lie.
No.
You were aware that you were speaking to police officers.
Yes.
You were aware you were speaking to police officers about something really important.
Yes.
You were aware at the time that it was important to be honest.
Yes.
You were aware at the time that it was important to be complete and accurate.
Yes.
Your claim now isn't that anything in here is either a lie or not complete or not accurate. Your claim is that you simply don't remember it.
No.
Is that right?
Yes, correct. I don't remember.
That's what she said.
But again, just a prior so-called plowing incident or snowblowing incident in the context of a shooting that took place within an hour or so, was that a big deal to you at the time?
What do you mean?
I mean, was this prior subject of a prior incident in a prior snowstorm at all important to you at that point?
I,
I mean, did you think it was a focal point? Did you think that was important?
I still don't understand what you're asking me.
Did the police tell you that it's really important that you accurately tell them about this prior snowstorm?
The one that happened that night or the one before?
The one they claimed that took place before?
No.
And in fact, in your statement, you indicate that it wasn't a big deal? Do you remember? Do you remember that at all?
What?
Telling them that it wasn't a big deal?
No.
I didn't know before you said it.
This is in New Hampshire.
Yeah, I'll just reiterate that the issues concerning kind of the impact of the moment to me go for the weight, not admissibility. By the way, we also have body cam of Officer Sergeant Knox, who was present during that half hour. Candidly, it shows a quite composed young woman, and I'd be glad to play that for the court as well.
Okay, the question is, how can you use this thing, right? I mean, impeachment's only good if you can adhere to the statement. I mean, did I say that before? And we're getting an answer that's like, I don't remember ever saying that. So how can you even impeach it? But I'm looking at the rule too. I mean, again, which specific rule are we saying this is going to come into?
I think the argument is Rule 8035, recorded recollection, the record that on the matter which is once knew about the count not recall and testified fully and actually was made or adopted by the witness in the matter of record of memory and actively requested and acknowledged. The rule will not say that she submitted the record to be read in evidence, but it doesn't get to see that it's fully good.
Yeah, it wasn't accepted by her.
When it was made.
It was made, but it wasn't accepted. You know what I'm saying?
It was made or adopted. So, Mike, having heard what here is witness.
Did they swear the rabbit in? That's crazy.
Witness testified was made on the matter that she wants to about, but she did not have a call. She did testify at the time she was careful, truthful, and accurate, including truthful and accurate in the statement. It was made at the time the matter was fresh in her memory. And for that reason, we allowed the statement to come in. Although, counsel, you're not talking about the whole statement.
No.
You're talking about the particular portion you're interested in having to do with private knowledge.
Yes.
Is the court allowed to in substance?
Yes, comes in the substance.
I don't think there's any addition to that, so I'll stand on the objection.
The objection of it, it does come in the substance, that's all I indicated. It gets read to the jury. It doesn't get presented to the exhibit.
I understand.
Very good. All right, we'll bring the jury back in. All right, that was a bunch of legal mumbo jumbo we need to worry about. You just need to answer the question and answers, okay?
Perfect.
Very good.
So they're gonna bring the jury back in here. So it's interesting they had to clear that up. Seems like they were having some issues with her remembering what happened. She said she gave a statement, wasn't able to review it. Not sure if she was telling the truth or not. So now I guess they're gonna go back through and present some of this to the jury. It looks like the judge is gonna allow it in. Let me know what y'all think about this testimony. We're gonna review the rest of this testimony probably in the next video / show. So y'all have to let me know what you think about her story. I want to get into the full story from her too, because it sounded like she was there when everything went down. So we're going to pick, let me see how much time of this testimony we have left. We've got about an hour and some change. Okay, so that's not bad. And then we actually might be caught up. So we got an hour and some change left. We'll get an early start tomorrow, finish up this testimony, and then we'll keep moving forward. Again, shout out to the community, man. I appreciate y'all. I got to show up the plaque again real quick. Y'all see the plaque back there? We finally got our plaque from YouTube. I'm going to hang it up probably tomorrow morning. So I don't know where I'm going to put it. I'm going to maybe put it right here so you can see it better. But is she related to the shooter or the injured party? So that is Jason Levesque's daughter. So this is his daughter. And she was actually in the snowplow with him while he was clearing the driveway. That's what it sounds like according to her. So we'll get into more testimony from her tomorrow. Thank y'all for the love. Make sure you like the video on your way out. And we're going to be dropping some more videos throughout the rest of the afternoon and into tomorrow. So make sure y'all stay tuned in for that. Appreciate y'all. Hope y'all have a great rest of your afternoon. Thank you guys for the 100K. We're going to keep pushing. And y'all know what to do. Keep growing, keep pushing, keep it classy. We gone. Peace. Rush Street said, did they swear in the rabbit? That's crazy, man.